Okay, the bottom of page 1 of 16, we have the buyer's initials, everybody should initial it, and the seller's initials, everybody should initial it. On page 2, and anytime you see a note up here, read the notes, okay? The notes are important, but for this note is not particularly important. You can read it later. All right, but the paragraph underneath there, we talked about due diligence fee. And we're going to talk about it a couple of times. First, it says here, should the buyer fail to deliver either the due diligence fee or any initial earnest money deposit by their due dates, or should any check or other funds paid by the buyer be dishonored for any reason by the institution upon which the payment is drawn, the buyer shall have 1 banking day after written notice to deliver cash, official check, wire transfer, or electronic transfer to the payee. So you have 1 day. If your check bounces, or if you default, or anything else like that, you're going to have 1 day to make good. And if not, then you're going to be held in breach of contract, which means that you could lose your earnest money and your due diligence money. You could lose all of that money that's up there. All right, you can be held responsible for it. Earnest money under the next line, earnest money deposit. We just talked about that. That is the money that's going to go in the escrow account. Okay, and we're going to hold it. If we go to closing, we're going to get it back as a credit. The escrow agent here, okay, the escrow agent, that's the person who is going to hold that earnest money. Now, it could be either the broker, and we talked about trust accounts before. The broker is going to have a trust account that's going to hold earnest money. A lot, I won't say most, it shouldn't say most. A lot more brokerages are going to giving the earnest money to the attorneys. And the attorneys already have a trust account, so they are just going to give them the money for the trust account and let them put it in their trust account. We're going to have to give it to them anyway. So a lot of cases, brokers just don't even want to handle a trust account anymore. They're just giving the earnest money to the attorneys. So it could be, this could be an attorney's name. It could be anybody's name. All right. Sam Hassel Agency Trust Account. Has to say trust account or escrow account. All right. Couple of things right here about earnest money. In the note, in the event of a dispute between the seller and buyer over the disposition of the earnest money deposit held in escrow, a licensed real estate broker is required by state law to retain the earnest money deposit in the escrow agent's trust or escrow account until the escrow agent has obtained a written release from the parties consenting to its disposition. So they're going to have to tell us, buyer and seller are going to have to tell us what to do with that earnest money. All right. Or until disbursement is ordered by a court of competent jurisdiction. So let's say the buyer and seller are arguing about the earnest money and they don't make a decision and they just say we're at an impasse. What we can do is we can give the money to the clerk of the court and let the court decide, right? Or go to the magistrate, file an interpleader and hand it over to the clerk. It's just easier that way. And let them decide what they're going to do with it, okay? Alternatively, if the broker or an attorney licensed to practice law is holding earnest money deposit, the broker or attorney may deposit the disputed monies in the appropriate clerk of the court in accordance with the provisions of the North Carolina General Statutes 93-812. All right, that's how you get rid of it. You cannot just arbitrarily give it to either the buyer or the seller. You have to have a dispute resolution. You have to be able to, buyer and seller have to fill out a form and say who's going to get the money. All right, or the court's going to do it, and then it takes you out of it. Bold print here, capital letters. The parties agree that a real estate brokerage firm acting as an escrow agent may place the earnest money deposit in an interest-bearing trust account, and that any interest earned thereon shall be dispersed to the escrow agent monthly in consideration of the expenses incurred by maintaining such account and the records associated therewith. So remember I said that inside the notes of the contract, it's going to say that it could be an earnest money account, an interest-bearing account, and that we are going to be able to keep that because it's in writing. Well, that's what that's saying. We're going to earn interest on your money and we're keeping it because we have to keep this account open. All right, so that's what that says right there. What's an effective date? You need to know what the effective date is, all right? And that effective date is when the last one of the buyer and seller has signed and initialed and we've communicated it back. Okay, that's the effective date. That's when this whole thing starts. That's day one, okay? Now in number 4, we're going to talk about due diligence in detail, but the due diligence is the buyer's opportunity to investigate the property with a transaction contemplated by this contract, including but not necessarily limited to the matters described in paragraph 4 below, all right? Buyer and buyer's sole discretion will proceed or will with or terminate the transaction. So these are some definitions. Due diligence fee is a negotiated amount that's going to be paid, and it's non-refundable except in the event of a material breach, all right? Contract by the seller. You can read that if you want. J is important here because we have an effective date when we get communicated back, and extended through this due diligence period, extending through 5 p.m. on this particular date. Now, remember we said we were going to have 21 days, right? That's what we agreed to earlier. So whatever 21 days is from today, that's the date we'd put there. Now, let's say for argument's sake, that is 13 and 7, February 8th, plus or minus a day, whatever it is. Let's say February 8th. 5:01 on February 8th, if I'm the buyer and I cannot get financing, if it's 5:01 on February 8th, I can't go to the seller and say, I want to get my earnest money back. I can't buy your house. I'm going to lose my earnest money. I'm going to lose my due diligence money and everything else. At that point, I can't walk away after that. So this is a hard line. 5 o'clock on that particular date. That's it. So up until then, if I wake up in the morning in the next 21 days or whatever we decided, and I just said, you know what, I'm not feeling buying a house, I can get my earnest money back. I'd lose my due diligence money, but for any reason or no reason at all, I can walk away. Except for after 5 o'clock on that date. I can't even request repairs after that. Again, anything 2 people can get into, 2 people can get out of. So we can agree, but that all being said, I have no right to walk away and get my earnest money back. All right. So that means even negotiating repair requests. And we'll get there when we get into section 4. We have both a settlement date and a closing date. They are separate. The settlement is when everybody gets together at the attorney's office, sign all the documents, make sure everything's in place, transfers any kind of information, goes back and forth, all right? And this is the date where we're going to meet. The closing is different. Closing different. The closing is, and this tells you the steps, completion of the legal process, which results in the transfer of title to the property from the seller to the buyer, which includes the following steps: the settlement, which was defined above, the completion of a satisfactory title update, the closing attorney's receipt of authorization to disperse all necessary funds. So the bank's got to say, okay, you can give out the money. Recordation, we have to record it, of the deed and deeds of trust, all right, as soon as reasonably possible. Upon closing, the proceeds of the sale shall be dispersed by the closing attorney, all right? If the title update should reveal unexpected liens, encumbrances, or other title defects, or if the closing attorney is not authorized to disperse all necessary funds, the closing shall be suspended and the settlement deemed delayed, which is your 7-day delay, okay? So this is what your closing is. This is what it's all about. This is how you do it. Let's talk about red. We didn't add this. This is in the contract. This red and these blues are in the contract, all right? This comes from the Real Association of Realtors who wrote these. But this warning, the North Carolina State Bar has determined that the performance of most acts and services required for a closing constitutes the practice of law and must be performed only by an attorney licensed to practice law in North Carolina. State law prohibits unlicensed individuals or firms from rendering legal service or advice. Although non-attorney settlement agents may perform limited services in connection with the closing, they may not perform all the acts and services required to complete the closing. A closing involves significant legal issues that should be handled by an attorney. Accordingly, it's the position of the North Carolina Bar Association and the North Carolina Association of Realtors that all buyers should hire an attorney licensed in North Carolina to perform a closing. So basically it says that you may get a paralegal to get you to sign some documents, but most of this work has got to be done by an attorney, not your realtor, not your broker, not the paralegal. You need to get there. Special assessments we'll talk about later. Special assessments, let's say they put roads in your community and the state's not paying for it or the city's not paying for it, so they're going to divide it up by every house in there. We'll talk about when those special assessments are payable and by whom in a little while. Number 2, fixtures and exclusions. And it says, warning, parties should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not part of this contract. Buyer and seller should be specific when negotiating what items will be included or excluded from the sale. Basically, what they're saying is, look, if it's not here, it didn't happen, right? If it's not in this 4 walls of this 16 pages, it didn't happen. We argue about what is a fixture and what is not. Well, here are the list of what we think is appropriate fixtures. The standards, right? Alarms, stoves, ranges, ovens, antennas, you can see them, floor coverings, garage door openers, landscaping, window and door blinds, water supply equipment, all right? So it's all listed, swimming pools, spas, hot tubs. These are all fixtures. Now, if you have any smart fixtures, you should delete or unpair them. If you have items that are leased or not owned, fuel tank, propane tank, things of that nature, satellite dish, you need to identify it that they belong to the company that owns them. You don't own them. Any other items that you agreed would not convey, they would go here. And if the seller takes them out, they have to repair any damage caused by the removal of those things. Okay, so this is where you say, I'm taking the chandelier in the dining room, or I'm taking the bathtub in the upstairs bathroom. All right, and as long as everybody agrees, you can do that, but you can't just arbitrarily do it. If any personal property is going to stay or go, it's going to be here. Buyer's due diligence process. This is number 4. This introduces us to the depth of due diligence, okay? So very important section here. All right, it's in the contract, but this is how we're going to learn it. So it says, warning, the buyer is strongly encouraged to conduct the due diligence during the due diligence period. If the buyer is not satisfied with the results or progress of buyer's due diligence, the buyer should terminate this contract prior to the expiration of the due diligence period, unless the buyer can obtain a written extension from the seller. Seller is not obligated to grant an extension, right? So if the buyer sees something that's not going to get done, seller doesn't have to give him an extension. Although the buyer may continue to investigate the property following the expiration of the due diligence period, the buyer's failure to deliver a termination notice to the seller prior to the expiration of that due diligence period will constitute a waiver by the buyer of any right to terminate this contract based on any matter relating to the due diligence. Provided, however, following the due diligence period, the buyer may still exercise a right to terminate if the seller fails to materially comply with the seller's obligations. So if the seller breaches. So if you do not do your due diligence and you decide to let something slide until after that, you're going to lose your money. Okay, you're going to lose your money. So they tell you you have to get all these things done. And we're going to tell you what's going to have to be done in about 30 seconds here. Okay, so you in that due diligence period, we said 21 days, right? $500. In that due diligence period, you have to get your loan, which means you have to do the application, you have to do the appraisal, you have to get some sort of commitment from your bank in those 21 days that says you're going to get the money. There is no contingency at the end of this. Let's say your 21 days is up and your details fall apart. No, not the seller's problem. You had while you were doing due diligence to do this. So there's a note, and this note explains that. There's no loan or appraisal contingency in this offer to purchase and contract. Therefore, buyers advised to consult with buyer's lender prior to signing this offer to assure that the due diligence period allows sufficient time for the loan process and for the buyer's lender to provide sufficient information to decide whether to proceed with or terminate the transaction. You better talk to your bank before you sign this, because if it can't get done and you lose it after that period of time, you're going to lose your earnest money. You're going to lose money. Right? So we have to get our loan then. We have to do our property investigation. So we have to do all of our inspections, right? We got to get the inspectors there. We have to look at all the HOA and documents while we're doing that. Make sure we got insurance. How much is insurance? Is it insurable? Right? Appraisals. You got to get those. We have to do a survey. Zoning and government regulation. What do we got? Are we in wetlands, right? Flood hazards. Where are we? Any utilities? Is it a private road, public road? Who pays for the utilities? Where do I have to go? Any special assessments that are going to come up? Are they putting new roads in? When's that going to be committed to? Do I have to sell a property? What if I have a house back in Maryland I need to sell? If I don't sell it before this due diligence period is over and it fails to sell, guess what? If I have to walk away, I'm going to lose my earnest money and my due diligence money. There's no contingency for that. So you're going to have to be ready for something that could happen there. Repair and improvement, right? If I want anything repaired or fixed or anything else, we have to negotiate those things prior to the due diligence. Now, it don't have to be fixed prior. So let's say we are 10 days into it and I have a list of things I want to get fixed. I can ask the seller to fix these things. I can renegotiate the price if I wanted to. Now, if seller says, yes, I'll put a new roof on there, he might not be able to get it done before the due diligence period is over, but as long as it's starting to get done and he's agreed to it, then he'll be committed to it, okay? But the seller doesn't even have to engage in negotiations. He can just say, no, I'm not fixing anything. As is, whatever. Does the buyer have to purchase the house during that due diligence period? No, right? Walk away for any reason. So again, there's a little dance that goes on here. Buyers advised to make any repair or improvement request in sufficient time to allow negotiations to be concluded prior to the expiration of the due diligence period. Any agreement that parties may reach with respect to repairs and improvements and as an addition to this contract must be in writing and signed by the parties. Okay, so we got to do an addendum. They're going to fix this, a repair addendum. Okay, we would do that. If any of those contractors damage the property, buyer's going to have to pay to fix it. And the buyer inherent indemnities, the buyer's going to hold the seller harmless if somebody gets hurt. The buyer's right to terminate. This is important. Provided that the buyer has delivered any agreed upon due diligence fee, and they're going to get that right away, the buyer shall have the right to terminate this contract for any reason or no reason by delivering to seller written notice of termination, all right, the termination notice, during the due diligence period or any agreed upon extension. Time being of the essence. There's those words again, right? We have to be inside those time frames. If the buyer timely delivers the termination notice, this contract shall be terminated and the earnest money deposit shall be refunded to the buyer. Okay. So if they deliver the termination notice, they're going to lose the due diligence money. That's the cost of walking away, but they're going to get the earnest money. That's due diligence. And we'll talk more about it later on. Buyer representation here. Do we have the funds to complete the purchase? And if we don't, how are we getting them? Are we going to get a loan or we have other funds? Who's the bank, right? First mortgage loan is going to be whom? We're going to fill that out here. Is it going to be FHA or VA? We have a lot of VA loans in North Carolina, right? Maybe you got an FHA, a lot of Department of Agriculture loans. So we have a lot of unusual loans, right? Or is it going to be conventional, and how much is it going to be? So it's going to be a second loan. That's where you would get that. If you're going to get funds from another source, put it here. Note here, buyer's obligations under this contract are not conditioned upon obtaining any loan or other funds from sources other than the buyer's own assets. Some mortgage loan programs and other programs providing funds for the purchase of the property selected by the buyer may impose repair obligations. This is such as VA and FHA. A VA, if you're going to get a VA funded loan, they're going to send a VA inspector And they're going to require, before that loan gets funded, that those things get fixed, that VA inspector. And they're going to have to come back and re-inspect. So that's what they're talking about there. Okay. So buyer may impose repair obligations and additional costs upon the seller. All right. Material changes with respect to funding the purchase of the property that affect the terms are material facts and have to be disclosed. Do I have a property to sell? Another property to sell? That would go here. Now, again, this note says this contract's not conditioned on the sale or lease of the buyer sale of other property. So if you go outside the due diligence, you get past your time and you haven't sold your house yet, and that house falls through, whatever, you can walk away from this contract, but you're going to lose your earnest money and your due diligence money. Okay? You have to be pretty darn sure that that's going to happen before you can get into this contract. Residential property owners disclosure statement. Did we get it? Did we receive it? Do we understand what's in there? Same thing with the mineral oil and gas disclosure statement. That's here. So the buyer has some obligations. Okay. Buyer shall take title subject to all special assessments that may be approved following the settlement. So let's say they're going to put streets in, and I'm the buyer, and my settlement date is February 15th. If we get approval for new streets on February 17th, buyer has to pay for those special assessments. If we get approval for special assessments for new streets on February 12th, the seller pays for the assessments. Okay, so if it's before the closing, the seller pays for the assessments. If it's after the closing, the buyer pays for the assessments. Which would kind of stink if you got to come up with, if you're the seller and you got to come up with that kind of money. So buyer's going to be responsible for these costs, all right? Loans, contract, changes in owners association fees, appraisals, title searches, title insurance, it's all spelled out. We're going to be able to disclose information, the buyer's lenders, the real estate parties, agents, all these people. We got to share information. This way we're getting, getting authorization to do so. Well, we've had buyers' representations. Here's the seller's representation. Do they own this property? Yes, no, maybe. What about a lead-based paint addendum? Do we need one of those? Was the house built prior to 1978? As the seller, I'm going to produce these documents, these owners association dues, right? Statements, master insurance policy, covenants and restrictions, rules and regs, all of these things, all right? All of these things are part of this. And under here, we're going to put the HOA, who's in charge, name of the property owners association, who's in charge, who's the manager is, and any kind of website and phone number. Some places have more than one, so there's space for two. Fuel tanks. Is there a fuel tank on the yard? You have a propane tank, you have an oil tank, right? Who owns them? Are they in use, right? Are they leased? Who owns them, right? There's the information for that. Tanks are included in the sale. Any fuel that's in the tanks. If you have a half a tank of propane out in your yard, it transfers with the sale. You can't charge somebody for the propane, right? Or you can't charge somebody for the oil. It's in the tank, it's part of the sale, just goes. You're going to have to, as the seller, you are going to have to give evidence of title, payoff statements, and non-foreign status. Let me see. Seller agrees to use best efforts to provide quality. I'm looking to say they're going to give us a general warranty deed. I'm trying to find the language here. And when I do, I will give it to you. Okay. It says it somewhere. Authorization to disclose. You may run into somebody, by the way, right here, number 3, that's Canadian. We do a lot of Canadian business. The United States government considers Canadians foreign nationals. In that effect, what will happen is if they sell a property here, the federal government's going to hold a percentage of the money. Last time I checked, it was about 15% of the gross sale. So the federal government's going to hold that money until the federal taxes get paid on that property, on the gains of that property. So they don't want particularly foreign national money. But anybody who does not live here permanently, they are considered foreign nationals, and they won't release all of the money until they square up with the government tax time. And we have authorization to access the property with inspectors, right? And good that we're all good there. All right, down here, D, removal of seller's properties. Seller shall remove by the date of possession is made available to the buyer all personal property which is not part of the purchase and all garbage and debris from the property. Has anybody ever bought or moved into a house that the seller left all of their stuff, all their garbage in the garage? Right? Yeah, there you go, Wayne. Right? I'm sure that it happens a lot. Oh, we didn't have a chance to get to the dump or whatever. And you go in the garage and all their garbage is in the garage. They didn't throw anything out. Not according to the contract. They're in breach of contract. Right? They need to get that out of the garage. Right? Before the closing. Before the closing. All right. Now, I did find where it says general warranty deed. Good title and legal access. Remember we talked about the different types of deeds, right? General warranty, special warranty, bargain and sale, quit claim. You remember those, right? We talked about those back in chapter 5, 4, 5. Well, letter G says good title and legal access. The seller shall execute and deliver a general warranty deed for the property in recordable form no later than the settlement, which shall convey fee simple, marketable, and insurable title without exception for mechanics liens and free of any other liens, encumbrances, or defects, including those which would be reverted by a current or accurate survey of the property, except the ad valorem taxes for the current year would be prorated through the date of settlement, right? We've done that before. And utility easements and unviolated covenants, conditions, and restrictions that do not materially affect the value of the property, and such other liens, encumbrances, or defects that may be assumed or specifically approved by the buyer in writing. So we're going to get liens. If we don't clear up, if the seller doesn't pay for them and we buy the property, guess who owns the liens on the property? The buyers do. That's why the seller, the lawyer has to, the attorney's got to clean those up. Get rid of them. How do you get rid of them? Get them cleaned up. Make the seller pay out of the proceeds. And sometimes the seller is so encumbered, he can't sell. Doesn't have enough money to sell, right? So that's why we need this, all right? The property must have a legal access to a public right-of-way. We got to be able to get to a road. We can't be basically what that's saying is it can't be landlocked. Remember we talked about easements, and easements are pertinent. In order for us to get to our property, you can't make us landlocked. Well, that's why. Property must have legal access to the public right-of-way. So even if I got to cut across somebody else's property, I have to get access, right? They can't shut me out. So this letter G explains a whole bunch of stuff we've been talking about. These taxes and fees are going to be prorated, right? Seller shall pay for preparation of deed and all other documents, all right? His own deed prep, okay? And then we're going to look at any excise taxes, deferred discounts, or rollback taxes, local conveyance, right? Now, oh, here, the deed is to be made to. Me and my wife are buying the house. So our names are on the financial responsibility. Is it okay for me to deed my property to my children? Sure, I can. So in that particular case, I can make out the deed in this particular case right there to my kids. They become the deeded owners of the property. I'm still financially obligated from up on the top, but in this particular case, way down here on page 10 of 16, I put the new owner's name on there. Doesn't have to be mine and my wife's. Could be anybody's. Okay? Could be anybody's. I can deed it to whomever I wish. Letter I here. Let's say that the seller doesn't want to make any repairs, but he's going to give the buyer an allowance to do new carpets. Let's say the carpets are in rough shape, but the seller doesn't want to replace all the carpets. So he goes to the buyer and he says, look, I know the carpets are in rough shape. I'll give you a $2,000 allowance at closing, and then you can go pick out the carpet you want for the $2,000. This is where we put that money. So it says agreement to pay the buyer's expenses. Seller shall pay settlement X amount of dollars towards any of the buyer's expenses associated with the purchase of the property at the discretion of the buyer and the lender, if any. So basically, we're going to pay some of his closing costs so they can take the money and go buy. So that might be where you put that money. A lot of times it's a flat dollar. Most times it's a flat dollar. It's not going to be a percentage of the sales price. Do not do that. It's a dollar sign. Any owners association charges and fees, all right? The seller shall pay any of those, okay? Payment of special assessments, seller shall pay in full at settlement. All special assessments that are approved prior to the settlement date, when payable in a lump sum or future installments, provided that the amount thereof can be reasonably determined and estimated. The payment of such estimated amount shall be a final payment between the parties. Now, if 2 days, you can imagine the problem this would be if 2 days before the closing, they give a road assessment to all of the houses in the development, and it comes to about, for argument's sake, it's not unusual to say $1,000 a year for 10 years for new roads in the development. Well, if I'm selling this house 2 days from now, guess who's stroking a check for $10,000? Me, the seller. Because on February 12th, instead of February 15th, they settled and they approved it on 2 days before it's supposed to close. That's the luck of the draw. You pay for it and you take it at closing, right? So if it's 2 days after, it's the buyer's problem. Negotiated repairs shall be made in good and workmanlike offer, and buyer shall have the right to verify the same prior to settlement. If you say you're going to put a new roof on, I want to check, right? Everything you're verifying at the walkthrough. Are we going to get a home warranty? Here's all the information for the home warranties. Now, when you sell your property, your homeowners association always has a little bit of a handout. They want some money, right? So these are charges by the homeowners association. So it has some fees that the seller is going to pay. All right. Get the if they have to get any information for the RPODs, if any fees charged for transferring the ownership records, the buyer's going to pay working capital contributions, membership fees, anything else that has to be and go into the general fund. So it's spelled out pretty specifically in number 9, the who pays what to the HOAs. Number 10 says basically we're going to prorate everything, right? Taxes on real property, any taxes on the personal property, rents, dues, all right? We're going to prorate them. Mr. Buyer, you're going to have 15 days of cost. Mr. Seller, you're going to have 15 days of cost, whatever it is. We're going to prorate them. Condition of property at risk and risk of loss, all right? The risk of loss is we're going to keep the insurance through the closing, okay? The insurance through the closing. And then if this property is damaged or destroyed, if the buyer still wants to buy it, the seller's going to give them the any kind of money that they have to put to it and any kind of insurance, and they're going to go to the buyer, and the buyer can still buy the property, or they can cancel the deal. Either way, okay, either way. All right, but we are going to keep this insured until after the closing. Okay, number 12 is important because it specifies the fact that what happens in a delay. What happens in a delay? So it says delay in settlement closing. This paragraph shall apply if one party is ready, willing, and able to complete settlement on the settlement date, but it's not possible for the other party to complete the settlement by the settlement date. This is usually like the bank delays, or the seller can't move, or maybe there's problems with the title, getting somebody to sign off on it. Something one way or the other that's causing one problem, one person not to be able to close. In such the event, the delaying party shall be entitled to a delay in settlement and shall give as much notice as possible to the non-delaying party and the closing attorney. If the delaying party fails to complete settlement and closing within 7 days of the settlement date, including any amended settlement date agreed to in the writing of the parties, then the delaying party shall be in breach, and the non-delaying party may terminate this contract and shall be entitled to enforce any remedies available to such parties under this contract. So we can hold if we don't close in 7 days. Now, a little bit of a trick here. Let's say I know that we're going to have to delay the closing for 10 days. Bank's not coming back to me fast enough. There's no way they can close by February 15th. We've been using that date. So me and Mr. Seller get together and we do an addendum form or an amendment form in this particular case, and we would just change the closing date from February 15th to February 25th. February 25th comes along, we can't close, we're still waiting. Am I allowed another 7-day extension from February 25th? Yeah, even though we extended it in writing, it's from the last date. So literally I would get from February 25th, I'd get an additional 7 days after that because we made an adjustment. The best thing to do if you're just going to close this way is leave the original date. And then after 7 days, decide what's going to happen here. How close are you? But if I give them 10 days in writing and we do an amendment, right? And it goes to the 25th, after that, they're still allowed 7 more days from the 25th. So you got to be really careful. Take every circumstance under its own. Maybe it's a problem that can be solved. Maybe it's a problem that can't be solved, right? So you don't want to extend the pain. So heads up on the extensions. Possession shall be at closing, all right? Now you can, if a buyer's going to get in there before closing, there's a form for that. Seller after closing, there's a form for that. Here's a list of all the different addendums that I showed you earlier. If we're going to use any of these, we should check it off. Big note to the real estate agents, North Carolina law, real estate brokers are not permitted to draft addenda to this contract. We're not allowed. We'll talk about a 1031 exchange down the road when we do financing. That's what a tax deferred exchange is. Let's see. Survival. What does that mean? Survival means that if I'm putting a roof on the house, and let's say, we got a 45-day close, and you came to me for due diligence and said, you need a new roof. And I said, all right, I'll give you a new roof. And I go start putting by the time I get to a roofing person to come out, by the time they can schedule me, by the time they can get that roof on, it may be past the closing date. So in that particular case, what we can do is we can continue putting the roof on. We can go ahead and close. But survival means that as long as we are working towards that effort to get it done, we can still go ahead and close. Buyer can move in, but the roof is still going to get put on and the seller is still going to pay for it. So all of those things that we're working at that we just couldn't get them done fast enough, then that is survival. It's going to supersede the closing of the contract, right? Because doesn't the contract ends at the closing? Well, if we want to still get that roof fixed, we're going to have to survive the closing, okay? That's what that is. Number 19 says this entire agreement is what's binding, and this is the only thing that's binding. It's got to be in this contract or in one of the addendums that we'll add to it. Otherwise, it does not exist. You can't wish it into effect. Number 20 gives us the right to use electronic means to do signatures and things of that nature. Conduct the transaction electronically. Execution is counterparts. Has anybody ever heard of counterparts before? Counterparts are, let's say that the seller has already moved. The seller moved to Rhode Island and he's gone and he's not going to be here for settlement date. So what the paralegals can do is send them all the documents that they can sign in front of a notary public. Send them the documents, they can sign them, and then come back. And in the meantime, have the buyer sign the same documents here. And then take the signature page from the seller had and the signature page from what the buyer had and put them together under the same document. So the seller's signature is going to be just the seller's under the document, page 50A, and the buyer is going to be the same thing, only they're not going to have both signatures together on the same page. So counterparts means that we're going to have sellers on one page, buyers on the other page, same document, okay? So we can share those.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.